whether Section 115 Subclause 3 of the Trademarks Act 1999 is inconsistent with second part of Schedule 1 of CRPC. This is the topic of today's video. Let me go through it. So Section 115 Subclause 3 of the Trademarks Act 1999 says that the offence under Section 103 to 105 shall be cognizable. Now what is cognizable is not defined in the Trademarks Act 1999, and that is why we need to take the help of the definition of cognizable offence provided in Section 2C of CRPC. What is that definition? Let me read that definition. Section 2C, cognizable offence means an offence for which and cognizable case means a case in which a police may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. As per the definition, police can arrest without warrant as far as the cognizable offence is concerned. Now, in accordance with the first schedule, this term refers second part of the first schedule to decide whether any offence is cognizable or not. As far as offence related to the Trademark Act is concerned, or offence related to the trademark is concerned, because the first part is related to the offence pertaining to IPC, and second part of the first schedule is related to any other law which includes Trademarks Act. That is why we need to refer that second part of the first schedule of CRPC. There are four parts therein. First is related to the offence. Second is related to the offence mentioned in the first part, whether that offence is cognizable or non-cognizable. Third part is related to that offence, whether that offence is bailable or non-bailable. And fourth part is concerned with the court, which court tries such offences. After this discussion, there are three other parts. Mention the offences as well as the imprisonment, and that three parts decide whether the offence is cognizable or non-cognizable. Let me read that three parts. First, if punishable with death, imprisonment of life, or imprisonment for more than 7 years, it is called cognizable offence, non-bailable, tried by the Court of Sessions. So this part is not at all related in respect of the provisions of Trademarks Act is concerned. Now second part, if punishable with imprisonment for 3 years and upwards, but not more than 7 years. Cognizable offence, non-bailable, tried by magistrate of first class. Third one is if punishable with imprisonment for less than 3 years or with fine only, non-cognizable offence, bailable by any and tried by any magistrate. So we need to concentrate as far as part 3 and part 2. Part 2 and part 3 are concerned because part 1 is not at all related in respect of this offences related to the Trademarks Act. Now whether the offences related to the Trademark Act fall within the purview of part 2 or within the purview of part 3 is the discussion in today's video. So considering part 2 of the first schedule of CRPC, let me discuss the language provided in Section 103 104 and 105 of the Trademark Acts, because section 115 subclause 3 says that these provisions are cognizable. So whether these provisions are the 115 subclause 3 says that the offences pertaining to section 103, 104 and 105 is cognizable. So whether they are cognizable or they are not cognizable in context with the second or third part of the first schedule of CRPC. Let me discuss it. Now first, section 103. What is the language of section 103? It says that imprisonment for a term which shall not less than 6 months, which shall not less than 6 months, but which may extend to 3 years, and with fine which shall not be less than 50,000 rupees, but which may extend to 2 lakh rupees. So not less than 6 months, not more than 3 years. This is the provisions for imprisonment. Now proviso. Provided that the court may, for adequate and special reasons to be mentioned in the judgment, impose a sentence of imprisonment for a term of less than 6 months, or a fine of less than 50,000 rupees. So it is the discretionary power. The proviso gives the discretionary power of honorable court with adequate and special reasons, that honorable court, that is the judicial magistrate first class, may impose a sentence less than 6 months or a fine less than 50,000 rupees. The same provision is mentioned as far as section 104 of the Trademarks Act is concerned. And section 105 says about imprisonment for a term which shall not be less than 1 year, but which may extend to 3 years. So 1 year to 3 years in section 103 and 104, 6 months to 3 years, with fine which shall not less than 1 lakh rupees. That is the section of provisions of section 105. Now, considering the term of the imprisonment provided in section 103 to 105 of the Trademarks Act 1999, the question arises is that whether the offences under provisions of section 103 to 105 fall within the part 2 or part 3 of the second part of the first schedule of CRPC. Let me discuss it. Now, as I discussed earlier, that section 115 subclause 3 says about the offences pertaining to the section 103 to 105 shall be cognizable. Hence, the ingredients of cognizable offence are required to be considered. What are those ingredients? First ingredient, police can arrest any person without warrant. Second, a case must be within the ambit of the second part of the first schedule, because first part is related to IPC. As far as the offence related to the trademark is concerned, section 115 subclause 3 says that it is cognizable offence. Now, there is no provision, or this act is silent about the arrest of the person without warrant in the Trademark Act. Section 115 subclause 4 says about DYSP may search and seize without warrant the goods. So section 115 subclause 4 says about search warrant and not the arrest warrant. Without search warrant, police may, that is police, but the up to a certain rank, that is DYSP, not below the rank of DYSP, that person may search and seize the goods without search warrant, not without arrest warrant. Hence, section 115 is totally silent in respect of the arrest of the person without warrant. And the criteria is police can arrest without warrant as far as the criteria of cognizable offence is concerned. This act is silent about, the Trademark Act is silent about the arrest of the person without warrant. So, when special statute, that is the Trademark Act, does not speak anything about the arrest warrant in the cases of offence related to the trademark, this condition for being cognizable offence is not satisfied, because it is the condition precedent to satisfy yes it is cognizable offence. Police can arrest without warrant, but police can arrest without warrant is not mentioned in the Trademarks Act 1999. Now another point, the second condition is that the case must fall within the ambit of part 2 of first schedule. Part 2 of first schedule of CRPC. Plain reading of this part says that first point of punishment with death, that is not at all applicable and relevant as far as I said earlier, the offences related to trademark is concerned. Second point says about punishment with imprisonment for 3 years. For 3 years term plays very important role and upwards, but not more than 7 years. So 3 years to 7 years. In other words, punishment of imprisonment must be for 3 years to 7 years and not less than 7 years and not more than 7 years. Sorry, not less than 3 years and not more than 7 years. Point 3 says that punishment with imprisonment for less than 7 years, less than 3 years or with fine only. Punishment with less than 3 years or with fine only. Now the language of the provisions of section 103, 104 and 105 of the Trademarks Act is required to be read in context with part 2 or part 3 of part 2 of the first schedule, that is point 2 and point 3 is a question. Plain reading of the language of these provisions indicates that it does not fall, that is, it indicates that it does not match with the language of the second point of part 2 of the first schedule, because the punishment with imprisonment for term which shall not be less than 6 months but which may extend to 3 years is mentioned in section 103 to 105. That is 103, 104 and 105 says about 1 year, because it is related to the repeated offence. This imprisonment cannot be considered to be fit as far as second point of the part 2 of first schedule of CRPC is concerned, in my opinion. Reason: punishment with imprisonment for 3 years and upwards, but not more than 7 years is the requirement of second part, and it is an essential condition for being cognizable offence. It is the minimum requirement for being cognizable offence, that at least 3 years punishment should be at least 3 years, not below the range of 3 years. This language of the language of the provision of section 103 to 105 for punishment is fit for part 3 of part 2 of first schedule, which says that the case related to the punishment with imprisonment for less than 3 years or with fine only is considered as non-cognizable offence. The language of section 103 to 105 of the TM Act, along with the proviso, because proviso plays very important role, mentioned therein invoking the discretionary power of the judicial magistrate first class for adequate and special reason to be mentioned for imposing the punishment for less than 6 months. Less than 6 months, or the fine that is less than 50,000 rupees. That proviso indicates that the punishment for offence related to Trademark Act is not minimum 3 years imprisonment, but it is 6 months to 3 years. And with adequate reasons, the magistrate may impose only a fine. There are chances that the magistrate with adequate reasons only impose the fine, and not at all that person is punished with the imprisonment. So under such circumstances, that provision is totally alien for being cognizable offence, or that case is totally alien for being cognizable offence. Hence the provision of section 103 to 105, whether or can the provision of section 103 or 105 be considered as cognizable offence? As mentioned in 115 subclause 3 of the Trademarks Act 1999 is concerned, is a question. Now, after completion of the Trademarks Act, I am going to make another video, that is part 2 of the same video, in respect of the provisions of Copyright Act section 63 in my second part. Please do consider to watch that part also, because I am going to discuss certain judgments of honorable various high courts and supreme courts in respect of such provisions, whether this offence is cognizable or not cognizable. Thank you very much.